Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London. I'm looking at a very important book which has come to us today from Sweet and Maxwell, the Thomson Reuters organisation of publishers. It's this book here called Class Actions in England and Wales. It's now in its second edition and it's been written by a lot of people. The general editors, however, are Damian, Maura, McIntosh and Gregg Rowan, but you can see there are a lot of other people listed on the front. That's the spine of the book there. I'll look at the book in a minute. I've given it a title, The Definitive Work on Class Actions, now in a completely updated second edition with a foreword by Sir Geoffrey Voss, Master of the Rolls. And in fact it's an important book because I think there's a lot of misconception about what a class action is. Let's look at the book first of all. There it is. It's a heavy book. It runs to something approaching 900 odd pages. You can see it's paragraph numbered. You can see there are lots and lots of footnotes. There is at the back, it's a little bit confusing, this particular publication, because there's a certain amount of information about Thomson Reuters right at the back, and then there are various other books which they have published again at the back of the book before you get to the index. And of course the index is by paragraph numbering, as you can probably see. It's quite a long index, quite useful. It's the legal taxonomy structure, which is very much the house style of Sweet and Maxwell. At the front of the book, you've then got the front page there. You can see the names of the people. There are a large number of people involved as contributing authors and assistant authors, but I'm only going to mention obviously the main or general editors. The foreword is well worth reading from Geoffrey Voss, who will be known to many of you for his work in the Bar Council, and of course his more important work as Master of the Rolls. He wrote the foreword in July, 4th of July 2022. Then there's a preface which is also worth reading from the three general editors. Then you've got the biographies of all of the people involved. After that you've got some table of cases. You've also of course got after that some statutes, the usual array of different bits and pieces at the front, then statutory instruments, and then after that table of EU and international legislation. So there's a lot of information there, and then I did find it very helpful. You have a table of abbreviations, always helpful. We always sometimes forget something. You just have that mental block. It's easy to do, but this is actually very helpful. And then you've got, for each chapter, you've got a nice mini list, basically, an index for each chapter, setting out what you need to look for. And I think when you look at the structure of the book and the actual index, you will find things very quickly. I do think it's quite useful to read the introduction, because it does actually kick off very nicely with talking about where we are at the moment with class actions, and you can see some of the footnotes, for instance, they're very substantial indeed. So what do we say about the book? Well, this. Is there any precise definition of the term class action in English law? No, apparently there isn't. The erudite editors and contributing authors of this well-established text make this point clear from the outset. This is not to deny, however, that large numbers of claimants and, more rarely, defendants can and do launch such claims within a variety of circumstances, and that's really what we're looking at here. Forget about the headlines in the tabloid newspapers and the American approach to it all. Let's think about English law. Whilst such a term as group litigation and multi-party actions have become increasingly commonplace, so too have various cases referred to as class actions, particularly in the past 4 years. And it has now been 4 years, of course, since the publication of the original first edition of what is now a distinguished law text, in which the term class action shines forth in the title. Now, I'm going to say something controversial here, because actually we've had something akin to this in the past, when you think of Donoghue and Stevenson and the Carlaw case, Carlaw and Carbonic Smoke Ball, remember that these were not just about that case, they were about a number of linked cases because the law needed to be ascertained. And I think that's an important point to bear in mind, and not directly relevant to class actions. Fortunately, of course, thanks to the supreme efforts put in by this team of writers, and much to the advantage of the busy practitioner in this area of law, is well nigh an indispensable work of reference which has now emerged as the second edition from Sweden Maxwell, because class action cases are becoming increasingly and relentlessly common, and I think that could well continue. To offer only one example, the case of the Lloyds and the HBOS litigation, that's Halifax Bank of Scotland litigation, is cited by the book's general editors as the first judgment in a shareholder class action in England and Wales, predictably paving the way for more such class actions in the not too distant future. And I suspect that's probably going to happen, although who can say? I mean, we didn't expect to have such chaos in both the civil and the criminal courts in terms of hearing cases and the aftermath of COVID, but that's where we are. Practitioners then, in this relatively new and fast developing area of law, will without a doubt welcome the assistance offered in this new edition, which has been fully updated to reflect recent key developments. 4 new chapters have been introduced on class action litigation, for example, and they've been added to the expanded text, which includes such issues as data protection claims, product liability matters, insurance and employment issues. So you've got a wide area here of substantive law issues. And as noted in the foreword by Geoffrey Voss as Master of the Rolls, this text is, quote, a detailed and practical guide to the conduct of class actions, which, he adds, have become a firmly entrenched, increasingly important part of the legal scene in England and Wales. They are being brought, he says, in almost every conceivable area, from international pollution, motor car manufacturing and pharmaceutical claims to financial services, shareholders and competition proceedings. And you've got there a very wide area, and it's interesting to note they're all basically of a global concept, and you can see that there is that influence coming in, I would suggest. However, I may be wrong, but it's something which is notable perhaps as an observation. Bearing in mind then the complexity, the breadth and the depth of this subject, we think it's reassuring to note that this book contains a mine of useful resources, including, as you would expect, the table of cases, statutes, statutory instruments, and a table of EU and international legislation, and the reassuringly extensive table of abbreviations, all to be found at the front of the book. It's copiously footnoted and featuring numbered paragraphs throughout, which is reflected in the index, and of course the book features a detailed table of contents at the front and the 11-page index to aid navigation, and you should, with the legal taxonomy, be able to manage that. Let me conclude shortly by saying this. As the designation of class action can conceivably become relevant in every aspect of law as time progresses, this definitive and eminently readable text should be considered an indispensable purchase for every law library and every practitioner. And I think it's an area that is going to develop in the 2020s. The date of publication of this second edition is cited at the 19th of August 2022. Let's just have one last look at it. There it is, a heavy book actually, sort of dark blue, hardback. You can see the spine. There's nothing on the back at all as such. Opening it up, claims for tortious negligence. There we go. That's right in the middle of the book. You can see again, this is looking very clearly at claims against manufacturers and designers. You can see the paragraph numbering, you can see the footnoting at the side and so forth. But you can get an idea with when they talk about claims against manufacturers and designers, you can see that it's not just one person, it's a whole group of people, and it's against the actual company concerned. So what you are getting, or what you will get with a lot of these class actions in reality, is quite a large number of claimants all coming together. I did one case some years ago now where in fact there were a whole series of small claims brought against my client, he was the defendant, in what the construction bar case involving faulty building works. It was interesting because they all linked together, and I suppose in many ways it was a class action in its own way, because they were picking on my client, justifiably as it turned out, for being a cowboy client. He was actually asking people to do work and then not paying them. So it was, frankly, he was a fraudster, and that became quite clear throughout the proceedings in the long trial that we had. But the point I'm making is that what happened there is a group of people got together. Instead of having individual claims, what the court process did was they linked everything together, so it was a group of claimants against the defendant. And that's really, looking at it in a slightly different way, that is probably the way we may go forward with some of the cases, bearing in mind the massive backlog that we have. Anyway, to conclude, can I please thank everybody involved, but specifically Damian, Maura, McIntosh and Gregg Rowan, and all at Sweet and Maxwell for an excellent book. I'm very grateful to review it. Thank you. Bye-bye.